So good evening, everyone. Thank you so much for coming tonight, despite the strike. I greatly appreciate to see you all here, so thank you very much. So this meeting, my presentation is entitled Breaking Down National Borders in the Cyberspace, the quest for an adequate principle of jurisdiction over online activities. So the idea is really to present you the first results of my research, okay? To give you like a general idea of what my thesis is about, and also how my thesis is structured, how I intend to develop my arguments. And so you have to know also that I don't have all the solutions yet. I don't even have identified all the problems yet. It's just, but I know a bit, like I have the general idea already, but so I don't have answer to everything, and even I'm still researching, okay? So this presentation is really meant to be very informal. So I know that you're not necessarily familiar with the cyberspace context, and you look at me with eyes like this when you talk about cyberspace, but it's just, the idea is just to get your first impressions, your first reaction after this presentation, and also I would greatly appreciate if you would give me your comments about the substance, of course, what you think, what are your first reaction and impressions, but also the way, don't hesitate to comment on the way I present my argument, also the logic of the presentation itself, and how I intend to develop it, whether it sounds original, whether it sounds good, or appealing, and all that, okay? So it's really what I'm expecting from this meeting, okay? So this presentation will last around 20 or 25 minutes, and I'm not gonna use a PowerPoint, because then I want to see whether I can be clear enough without a PowerPoint. And then if you understand everything without a PowerPoint, it means that it's okay, I want a good try. So that's my philosophy. Not because I was lazy, but just... Okay, so this presentation, so since the emergence of the notion of sovereignty back in the 16th century, the territoriality principle has always been the most natural principle of jurisdiction in international law, making its use very incontroversial and therefore never put into question. And actually, if you look at the international theory of jurisdiction today, it's actually divided between a legitimate, absolute territorial jurisdiction on one hand, and then on the other hand, you have an extraterritorial and sort of problematic jurisdiction. And actually, the development of the internet in the middle of the 90s actually didn't change anything in this regard, because states actually instinctively, sort of spontaneously, relied upon the territoriality principle over the internet in the cyberspace. But the problem is not actually whether they can use the territoriality principle to exercise the jurisdiction over the internet, but whether they should. Because what we're going to see actually, what states did is that states say, well, we have a new technology, our most natural principle of jurisdiction is territoriality. I don't really look at the features of this new technology, the territoriality principle is going to fit. Therefore, I apply my territoriality principle over online activities, what states did. But actually, what we're going to see during this presentation is that the territoriality principle does not fit the cyberspace. The internet activity challenges the paradigm of territoriality in international law. And therefore, what we have to do, we must explain what are the reasons of such an inadequacy, first of all, and also what are the other avenues open to states to replace territoriality and still exercise the jurisdiction over the internet. Okay? So, in other words, what I try to demonstrate is that states must break down the national borders in the cyberspace and look for another and more adequate principle of jurisdiction for the cyberspace. So here, just knowing that, I can just already give you the general structure of my thesis. First chapter, and here, tell me if you, afterwards, tell me if you think it's logical and all that. I'm just telling you what I'm trying to do. So the first chapter is the paradigm of territoriality in international law, because here again there's a question of legitimacy, because I think that one cannot assess the legitimacy of a certain principle in a certain context, between the territoriality principle in the cyberspace context, without first presenting the principle, okay, and showing a good knowledge of it, okay? So the first chapter is just about the paradigm of territoriality in international law, as it stands, as we know, not related to the cyberspace context, just show the basics, so origins, historical origins, rationals, various interpretation, and also main features. So that's the first chapter. Then the second chapter is the use of territoriality in the cyberspace context. How the territoriality principle has been used in the cyberspace context on the internet, and more importantly, what are the deficiencies arising from such a use. And then the third chapter is that since, because of all these deficiencies, the conclusion is that territoriality principle does not fit. Third chapter is what are the possible avenues open to the states to exercise, to replace territoriality and to exercise jurisdiction over online activities. In both actually civil and criminal matters. And that also maybe we can discuss that a bit later. And then I have a fourth chapter, but I still don't know whether it will be a chapter or something independent from my thesis. Because if we take a step back, when you think about the nature of the cyberspace, a borderless world, you don't really know what it is, but what you know is that territories and borders do not really play an important role. Nature was actually not really different from the normal world or the real world. The globalized world, the 2014 world where we live, where territories and borders do not play a very important role. So actually, if nature rise, it's pretty much the same thing. The results you get in chapter 3, the possible avenues for states to exercise the jurisdiction, then maybe you can apply these to the real world. I mean, and then to assess the legitimacy of the territoriality principle in general, not only in the cyberspace context. Okay? But that's the fourth chapter. I still don't know whether I will include it, or even though it's a logical continuation of the reasoning, I still don't know whether I will include it. It's still pending in my mind, but at least I have the first chapter in my head now. The first chapter that I'm drafting now. So now let me just go a little bit more into the substance and let me develop a little bit my arguments. And first, I think the starting point, which should be the primary nature of the internet. How the internet was originally conceived by lawyers, by international lawyers. And originally, the internet was considered as two things. First of all, a borderless world. No borders on the internet. And second of all, a space of its own, a separate legal jurisdiction located beyond the real space, okay? And actually that is in fact how the cyberspace captured our legal and even human imagination. That's why we're talking about the internet, or the cyberspace, or even the cloud, like something you don't really know what it is, the cloud. When people talk about the cloud, you don't really know what it is. So it's like a separate legal jurisdiction, something, just a space of its own, okay? And in that perspective, at the very beginning, in the first place, it was therefore assumed that traditional rules of state jurisdiction, which are, first of all, established for the real world, okay, plus very closely related to the concept of territory, do not fit in the cyberspace. That was actually the primary conclusion of the lawyers in the mid-90s, okay? The original conception of the internet. However, as the importance of the internet was growing exponentially, states quickly realized that such an absence of jurisdiction, such an absence of regulation on the internet was very problematic, and it was actually threatening the sovereignty. Okay? And if we take the words of Dr. Thomas Schulz, what he says is that the tide reversed, or the dark side of the web manifested itself. That's what he says in his article published in the AGO. For instance, let's take an example. Conservative non-Western states, okay, started being very concerned about Western ideas and Western culture flowing into the territory via the internet, and therefore putting in danger their own local values. Same for Western states, who became very worried about apology for terrorism against them flowing into the territory via the internet. And then to take a practical example, on which I will come back later. France didn't want, for instance, Nazi items to be sold online, okay, to people located on the French territory, okay? And it's an example I will come back after, because French criminal legislation prohibits the selling of, it's not like this in the States, but prohibits the selling of Nazi uniforms, let's say, okay? So therefore you cannot do it, you cannot sell Nazi uniforms to people in a physical store located in France, okay? And therefore France say, well, but that doesn't really, I mean, on the internet it's exactly the same thing. If people can have access to a website from France and buy actually Nazi uniforms from the French territory, it's the same. If I prohibit physical stores, I should prohibit also virtual stores selling Nazi uniforms to people located in France. So states quickly realized that the internet was really putting the sovereignty in danger, that was really threatening their sovereignty. And because there exists a very tight link between the notion of sovereignty and the notion of territoriality, state very naturally, and we cannot blame them for that, instinctively relied upon the territoriality principle. And that's why they decided to integrate the cyberspace within the territorial framework, okay? And therefore subsequently to exercise the territorial jurisdiction over online activities quite naturally. Because why? Because if you look at the Westphalian system, in the Westphalian system, the notion of sovereignty and the notion of territoriality are very closely connected, okay? Territoriality is more than just an expression of sovereignty, as it is commonly asserted. Actually, territoriality is the necessary corollary of sovereignty. Okay, territoriality determines actually the existence of sovereignty, according to the state. So, this is why states are so attached to the territoriality principle, because if you touch the territoriality, what they think is that you touch the sovereignty. So giving up on territoriality means what? Means giving up on my sovereignty. So that's why when they saw with the cyberspace thing happening, that their sovereignty was putting in danger, what they did is that, well, they relied immediately on the territoriality principle. That's quite logical. Okay? It is important to point out this, because like, this is why states rely upon the territoriality principle. But the problem is that the exercise of territorial jurisdiction engenders a series of very serious theoretical and practical issues and deficiencies, which at the end of the day put into question the adequacy and the legitimacy of the territoriality principle for the very particular cyberspace context. So what are these deficiencies? So I'm not going to list all these deficiencies. First of all, because I have not identified all of them, but I'm just going to give you some. First of all, from a theoretical point of view, and you can tell me later what you think of that, but from a conceptual point of view, conceptually speaking, the internet has no territorial dimension. The internet has space-defying qualities. It is a borderless world disconnected from any particular territory. Territoriality has no relevance in the cyberspace context. For instance, take online communications. Online communications are routed from, to, and through territories which are largely unknown to the users. Unknown but also irrelevant. Now take websites. A website is not a place. A website is just a code, like nothing else than just a code. Okay? And this code may actually be located in a server which is completely unknown to the user of the web page. And the author of the web page has no idea where the server is located. And maybe also the author of the web page has leased the internet access from a commercial provider that maintains hardware everywhere in the world. So conceptually speaking, it makes no sense to speak of territories, borders, and therefore territoriality in the cyberspace context. It makes no sense, but I think it's also wrong. It's also wrong. And let's take a practical example. Let's take a pedophile. Okay? A pedophile operating over the phone and a pedophile operating over the internet. Okay? A pedophile operating over the phone. When the pedophile calls the child, okay, he knows where the child is. And actually, even if he knows the country quite well, he can even say in what part of the country the child is located. Pedophile dials plus 412298. He knows that the child that he's calling, that he's talking to, is located in Switzerland. And if he knows Switzerland a little bit, he also knows that his kid is actually located in Geneva. So there is a territorial dimension in the relationship between the pedophile and the child. And so Switzerland can legitimately prosecute the pedophile on the basis of the territoriality principle. In the terms of Frederick Mann, okay, who was this great international lawyer who developed this doctrine of jurisdiction in international law, there is a genuine link between the situation on the phone, over the phone, and the Swiss territory. So it is fair and reasonable for Switzerland to prosecute the pedophile on the basis of the territoriality principle. Now take the same pedophile but operating on the internet. On the internet, in 99% of cases, the pedophile doesn't know where the child is. And the child doesn't know where the pedophile is. And actually it doesn't matter. It's completely irrelevant. There is no territorial dimension in the relationship they have. So therefore, if the child is in Switzerland, Switzerland, according to me, cannot prosecute the pedophile on the basis of the territoriality principle. I'm not saying that Switzerland cannot prosecute the pedophile, but not on the basis of the territoriality principle, because according to me, there is not the genuine link which is required between the situation and the state asserting jurisdiction, it's everything but the territorial link. So maybe what you can use the nationality of the victim, okay? And rely upon the passive personality principle, but not the territoriality principle. So we see that conceptually speaking, it doesn't make sense, and it's actually wrong to speak of territoriality on the cyberspace. Now the practical deficiencies arising from the use of territoriality on the internet. And here let's divide between the adjudicative level and the enforcement level. And we see that at both levels, in both cases, the territoriality principle leads to some very serious practical deficiencies, which put into question the adequacy of the principle online. Let's take the adjudicative level. Subjective interpretation of territoriality that you know. And here I refer to this case that Dr. Schulz is talking about in his article, the Louis Ferraud versus viewfinder case in the state. Louis Ferraud, what it is? Louis Ferraud, it's a French design company who organized a fashion show in Paris. Some pictures were taken at this show, okay? And these pictures were posted online by a US company called Viewfinder. And this company is based in New York. And this company uploaded, okay, the pictures of the show online, but from New York, okay? So they've put the pictures online from New York. Louis Ferraud, the French company, considered this as a copyright violation, okay, and filed a complaint in France. And then the French court decided in favor of Louis Ferraud and awarded damages to Louis Ferraud. And then Louis Ferraud, they went to New York and they asked an American judge to actually enforce the French decision. And what the New York court did is that it refused to do so on the basis that the French court didn't have jurisdiction. Because what the New York court says that the appropriate rule for jurisdiction online is the subjective territorial principle. So therefore, a court only has jurisdiction over activities originating, okay, from its territory. So in Casu, since the pictures were uploaded from the US, the New York court considered that the French court didn't have jurisdiction and therefore refused to enforce the decision. So here we see that the subjective interpretation of territoriality, if it's followed globally, it doesn't fit. Because why? Because like if you take such an approach, it will make forum shopping very easy. And then it will be sufficient to go to find a country with the appropriate legal regime and publish any content from there. And actually this content will still be accessible from the place where the publisher actually wanted it to be published. So we see that the subjective interpretation of territoriality doesn't fit the cyberspace context. And same with the objective interpretation. And here the objective interpretation, I refer to the famous Yahoo case, maybe the most important case in cyber law back in 2003. A very easy fact. An American citizen on his web page, okay, hosted by yahoo.com, was selling Nazi items, uniforms, pictures of concentration camp, Zyklon B canes, and all this kind of stuff, okay? This is allowed under the First Amendment of the US Constitution. You can do that. But the problem is that this web page was accessible, since it was online, this web page was accessible from everywhere in the world, including France, where actually in France, the selling of Nazi items, it's illegal. So what happened? You had a French Jew who decided to initiate proceedings, okay, against Yahoo.com. And what the French court said, it asserted jurisdiction on the basis of an objective interpretation of territoriality, because the damages actually occurred in France, okay? And ordered Yahoo.com to take down the page and to pay a symbolic fine, okay? And what Yahoo did, of course, Yahoo was revolted and protested strongly against such an order, because they say, and it's actually true, they say that in such a case, what they have to do, they have to make sure that any information that you find on web page that Yahoo hosts actually complies with the national legislation of every country in the world. And it's same for all websites, all information. And it's what we call, Jonathan Zittrain from Harvard said, the slowest ship in the convoy problem. The idea that since information posted on the internet is accessible from everywhere in the world, if the objective interpretation of territoriality is given application, then virtually every state has jurisdiction as long as the information does not comply with its own legislation. And as a result, if information producers want to avoid being held by an expected court, what they have to do is that they have to comply with the national legislation of like every country in the world. And therefore with the most restrictive law in the world, if they don't want to be held by a national court, unexpectedly. It's what we call the slower sheet, this most restrictive law. So here there is no need to explain further that it's absolutely unreasonable. You cannot ask an information producer if you send something on the internet to comply, to make sure that you comply with like almost 200 national legislation. And plus if you do that, it's the end of the internet. So here again, such as the subjective interpretation of territoriality, the objective interpretation is clearly not adequate for the internet. Now the enforcement level. And it's actually the last deficiency, because here in addition to using the territoriality principle at the adjudicative level, states also use it at the enforcement level to regulate the flux of information flowing into the territories. And it's what we call, in practice, the practice of territorial zoning. What does it mean? It means that depending on their own local values, states refuse access to the territories to some information, if they consider this information violating their public order. Okay? So for instance, Iran filters out any pornographic websites trying to access the Iranian territories. As a result, you cannot access pornographic websites in principle from the Iranian territory. France is doing the same with websites selling Nazi items. So as a result of that, what do you have? You don't have one internet anymore. It's a myth. You have one internet per country. Because depending on where you are, you don't have access to the same information. If you access the internet from France, you don't have access to the same information as if you access the internet from Iran. So at first glance, what you can say, well, it's quite legitimate for states. I mean, they have a public order, they want to protect it. Well, if you consider Iran, that it is legitimate for Iran to prohibit pornography, so therefore you allow them to prohibit the access of pornographic magazines at the physical border, okay? But then it's quite legitimate for Iran to also prohibit pornographic websites trying to get access to Iran. Because at the end, what Iran doesn't want people from its territory having access to pornographic information. It doesn't matter whether it's a pornographic magazine or if it's like a pornographic website. You can say that at first glance. It makes sense. But actually, I think this practice of zoning, which is widely practiced, must absolutely be turned down, and thus for several reasons. The first reason is that it doesn't work. I mean, it doesn't work anymore. Like 15, 20 years ago, the regulation of information on the internet was feasible because the traffic of information was not as important as it is today. But today, forget it. I mean, it's impossible for state to regulate information coming into the territory. Take Twitter. You close a Twitter account, okay? You close a Twitter account, well, but tomorrow you open another one. And it's the same for everything. So it's not possible today. Second reason, it territorializes an aspect of life, which is the cyberspace, which was thought to transcend territories. And it goes against the primary nature of the internet, to territorialize it, to carve it up into different compartments, okay? And actually, I find this particularly unacceptable. Since when you have a new technology, you have to adapt this new technology to your existing law? Why not doing the contrary, adapting your law to the new technology? Then third, it can be used as a very powerful instrument of repression. Look at the Arab Spring, turning down the Facebook and Twitter. Fourth reason, it violates, and here I will greatly appreciate comments from the great human rights lawyers that you all are. It violates the emerging human rights to information. I'm not talking about the freedom of expression, but is there human rights to information? To have access to information wherever you are in the world. Fifth reason, it hampers international trade. And sixth reason, above all, it leads to an informational impoverishment of the cyberspace. So I think this practice of zoning, this territorialization of the internet, this use of territoriality at the enforcement level has to be rejected. So therefore, we have deficiencies, practical, theoretical. So therefore, the time has come to break down national borders on the internet, to shift away from territoriality and adopt another principle of jurisdiction, more adequate, more appropriate for the cyberspace context. Because since the cyberspace is so important, crucial in these days, so important these days in the development of our society, it cannot be free from regulation. I'm not saying that states cannot exercise the jurisdiction on the internet. That I'm positive. But they have to do it on the basis of another principle of jurisdiction, because territoriality is not adequate. So what are the other avenues? Various avenues I was considering. I have not identified all of them yet. I'm still researching. But I have 4 ideas for the moment, and you can tell me what you think of them. Of course, the first thing we think about is to rely upon another existing principle of jurisdiction. Instead of territoriality, we could think that states could use, for instance, the active personality principle and only have jurisdiction over the national residents committing wrongs online. It doesn't seem to me crazy. Then they could also use the passive personality principle and only exercise the jurisdiction when the nationals are victims of wrongs committed online. First option. Then second option, relying upon a new title of jurisdiction, completely new, brand new, sui generis. But here again, it's not easy. It's not easy. Why? Because titles of jurisdiction are to be found in international law and not into the sovereignty of states. From one day to the other, a state cannot decide to rely upon a new title of jurisdiction, completely new. I mean, sovereignty is a legal notion. Sovereignty is not a factual notion. States are legal entities which are submitted to international law, and that's the famous Lotus debate, whether in traditional or modern approach to international law. But to me, titles of jurisdiction, principle of jurisdiction, are attributed by international law. So therefore, if we look for a new title, okay, but we have to find this new title of jurisdiction in international law. So whether in customary international law, why not? And actually, it can be very quick if all states decide all of a sudden to use the same new principle of jurisdiction, and if all the requirements for the development of a new customary rules are met. Why not? Or a treaty. You can have a treaty. Second idea. And then the third idea, which is my favorite. Cyberspace as a global common. And this is the avenue I prefer. I think it's quite interesting here, I think. Because here it is a conception of the cyberspace which is based on the assumptions that cyberspace is a space and it's not a mean of communication. And that maybe we can discuss afterwards, whether you consider cyberspace as a space or as a mean of communication. If you consider it as a cyberspace, we can consider the cyberspace as a global common, what we call in Latin, sorry Antonio for the pronunciation, res commune omnium. Exactly like the high seas or the outer space. Global common, like things which belong to everyone. Why can you consider them? Because like any other global common, the cyberspace is characterized by ubiquity, anonymity. Exactly like any other global common. So on this basis you could consider. But the most important is about the consequences of this. If you consider it as a global common, it means two things. First of all, that you cannot exercise your territorial sovereignty over the global space, over the global common, or therefore over the cyberspace. If you take the high seas, tomorrow France cannot decide to exercise its territorial jurisdiction permanently on part of the high seas. You cannot say, well, this part of the high seas, this GPS position is mine, it's my territory. You can't. So therefore, if you, by analogy, you do it on the cyberspace, the practice of zoning that we were talking about, this famous territorialization that I'm fighting against, is not possible from a legal point of view. But it doesn't mean that states do not have jurisdiction. Because if you take the high seas again, okay, states cannot exercise the territorial jurisdiction over the high seas, but they can still exercise their jurisdiction over certain situations taking place on the high seas. Like states, on the basis of the flag state principle, they can exercise the jurisdiction on the basis over situations taking place on vessels which have the flag. And same for the side. So on the basis of the personality principle. And states could, so by analogy, if we go back to the cyberspace, here, so first, they cannot exercise territorial jurisdiction, so they cannot carve it up the internet, but they can still have jurisdiction on the basis, not on the territoriality principle, but on the basis of the personality principle. But then after, it has yet to be found what will be the personal link. Okay? The individual, the author, the nationality of the author, the nationality of the victim, the nationality, if we can talk about like this, about the server. So it has yet to be found. And then another one, and it's the last one. Rethinking territoriality. Because if it can be demonstrated that the inadequacy of the territoriality principle in the cyberspace context is not due to the features of the internet, but due to an obsolete notion of territory, one can attempt to rethink the notion of territory. Because like at the end, the inadequacy of the territoriality principle in the cyberspace context is not necessarily the fault of the internet. It can be the fault of the territory, which is this notion on which is based the territoriality principle. Why not? For instance, why not considering territories, I know it's a bit conceptual still, but why not considering territories not as a topological notion, but as a social space? Because traditionally speaking, territories, it's a topological notion, a physical space delimited by physical boundaries clearly identified, okay? But the idea here would be to shift away from this conception and consider territory as a social space. Because after all, social communities are nowadays rather defined by the common features the members share, rather than by their territorial presence. And in the past, territorial dimension of social communities was very important. But today, is it the case still? So, and actually this idea of rethinking the notion of territory, it's, I think, the most appealing for states, not for us, but for states. Because if you tell the states, well, shift away from territoriality and adopt a new principle of jurisdiction, what they're going to say? Then we go back to what I was saying at the beginning. They say, no, but if you touch my territoriality, you touch my sovereignty. If I give up on my territoriality, I give up on my sovereignty. I can't. I'm too scared. But what you can do, you're more smarter than the state, and you say, okay, we don't touch your territoriality, but I'm going to touch the notion on which territoriality is based, which is the notion of territory. And actually, that's why I say that this idea, it's, I think, the most appealing one. And then the last part, which is this famous fourth chapter that I'm not sure whether I will integrate it as a chapter or as something else independent, but it's logical continuation of our reasoning, very quickly. Since the cyberspace is a paradigmatic illustration of the globalization movement of the world as it stands today, a world where borders and territories have very minimal roles, we could apply these results, so these four ideas that I have, to the normal world. So here there will not be a question, not anymore a question of the legitimate use of the territoriality principle in the cyberspace context, but the more general question of the legitimacy of the territoriality principle as a principle of jurisdiction in today's world. Because when you look at the cyberspace and the world as it is today, it's pretty much the same thing, I mean, grosso modo, okay? And actually, and it's my last point, international law is the last domain where they didn't shift away from territoriality. If you look at, for instance, sociology, which is very closely related to law, close to law, okay? It's been a long time they shifted away from territoriality. So why not international law? Thank you very much.